Tom Steyer, on the other hand, comes in without any government experience with an incredible amount of money. He smashed all self-funding records in this race, almost $200 million to his own campaign, and running as a billionaire progressive.
Against billionaires. Hey everyone, from KQED in San Francisco, this is Political Breakdown. I'm Marisa Lagos. Today on The Breakdown, a recent California Supreme Court decision in favor of a man who spent 6 months in jail after buying a $7 hamburger with someone else's credit card. It could fundamentally end the use of cash bail in California. That's if judges and prosecutors abide by the ruling. We're going to dig into the state of affairs with the two lawyers who argued on behalf of that man. But first, the latest in the governor's race, less than 2 weeks before the June primary. KQED politics correspondent Guy Marzorati is here to break down some of the new polling and talk about our own reporting into two of the top Democratic candidates. Hey, Guy.
Hello, the stretch run.
We're here. We've almost made it till the end. We are headed into the really final week of the campaign. And tell us, what's the state of play? What are we seeing in polls? Have we seen any new polls this week?
Yeah, we saw a new poll that was commissioned by the state Democratic Party. This is one we are looking forward to because it comes after we've made it through all the debates. We've gone through the debates where Xavier Becerra, the new Democratic frontrunner, took a lot of attacks. We've seen a lot of ads against Becerra, and the other Democrat kind of leading the polls, Tom Steyer, he's been attacked as well. So, we are very curious to see, okay, how would all of this stuff kind of bake into perceptions for voters? And we saw this poll come out this week showing Steve Hilton leading the field overall, the top Republican, pulling pretty far away from Chad Bianco, who is the only other major Republican in the race. Xavier Becerra just behind him, 22%, 21% for Xavier Becerra, and then 15% for Tom Steyer. So I think one way you could come away looking at it from, at least from the snapshot of this one survey, is 3 candidates competing for 2 spots in the June primary.
And very unlikely, I want to underscore, that in any world that 2 Republicans would move along. It is looking very likely it could be Hilton versus Becerra or Steyer.
Right. And if we've seen any really clear trend line over the last couple months or so, it's ever since beginning of April, President Trump endorsed Steve Hilton. Steve Hilton in every poll has kind of just grown his share of Republican support to where now, yes, very, very unlikely that we'd have a chance of seeing 2 Republicans in the general election.
Absolutely. All right. Well, because there are only 2 spots in this runoff and there are essentially 3 people competing for it, we have seen attacks flying between those 2 Democratic frontrunners, Xavier Becerra, former Attorney General, former Health and Human Services Secretary, and billionaire Tom Steyer. Can you just briefly tell us what are their closing arguments as we head into what is the end of such an unsettled and almost bizarre race, honestly?
Yeah, really bizarre and kind of a fascinating path to this point for both of these men. Becerra always had the resume, right? Like you said, former Attorney General, former Health and Human Services Secretary, but had been languishing in the polls for a long time. He sees this resurgence after Eric Swalwell gets out of the race. Tom Steyer, on the other hand, comes in without any government experience with an incredible amount of money. He smashed all self-funding records in this race, almost $200 million to his own campaign, and running as a billionaire progressive.
Against billionaires.
So it's both of these guys have a really kind of fascinating case they've been making. The closing argument for Becerra is clearly, judge me by my experience. He has a resume that no one else in this race does. For Steyer, it's judge me by my enemies. Mm-hmm. You look at the groups that are spending millions of dollars to oppose his candidacy. He wants voters to think, look, if all these people are opposing me, I must be doing something right. That's kind of his closing argument. And I think it's what motivated both of us to say, okay, let's take them at their word for that and dig into both of those. So you spent a lot of time digging into Becerra's record as Attorney General, and I looked into this clash between Steyer and the group spending the most against them, which is PG&E.
Right. And so PG&E and sort of supported by other business groups and utilities. But why are they so laser focused on Steyer? And when we talk about spending, what are we talking about? How much money here? Yeah,
at this point, it's over $12 million just from PG&E. They've never spent like this before in a governor's race. And again, these are all through outside committees. So this is an outside committee that's been running ads against Steyer and very recently starting to include some pro-Becerra language in their ads as well, as they kind of see this as kind of a 2-horse race. I would say for these businesses, it's both the personal. I think they clearly don't view Steyer as someone that they can work with if he's elected. He's running on a progressive pro-tax platform. And so it makes sense if you're the Chamber of Commerce or you're the realtors, you see this idea of Steyer day one promising he's going to call a special election, raise commercial property taxes, bring in money for healthcare education. They view that as a threat. The utilities is really interesting because here it kind of cuts both ways. Steyer has had a really ambitious plan to reduce electricity rates, and there's a lot of pieces to it that we can get to. The one that I heard from experts that is most threatening to the utilities is this idea of cutting their shareholder profits, basically diminishing the guaranteed rate of return that shareholders can get on their infrastructure investments. So you've seen PG&E pour a lot of money in against Steyer. You've seen some of the executives at these other utilities call out Steyer by name. Steyer's relished that because I think if you step back and look at the politics of it, the opposition to PG&E unites so many pieces of the Democratic Party. It's
and potentially some independents and Republicans.
That's a great,
frankly.
yes, exactly. People who might not be super engaged in politics because you draw in, look, everyone who's been paying higher electricity rates in the last couple of years. You draw in kind of the urban progressives, maybe they're wary of monopoly power. People living in the exurbs who deal front hand with potential wildfires caused by utility equipment.
And raising rates when you're living somewhere where you have to pay for air conditioning,
yes,
and, heating in the winter.
And then even like the Democrats, like in the wealth, I'm thinking of like the Palo Alto, Irvine Democrats. They're furious that PG&E has been trying to pull back rooftop solar benefits. So you're with the anti-PG&E argument that Steyer is setting up, he's really touching a lot of different parts of Democratic constituencies. And so that's why I feel like kind of both sides are leaning into this.
Yeah, and it is interesting. I mean, 2 points I'll make, and then we should talk about Becerra. One is what he's saying is not just what we heard in, I think, some other races like Abigail Spanberger, like where there's sort of these like vague promises to cut rates. He does have a very specific idea about cutting profit margins, which are approved by the state. And the second thing, just to underscore, none of the ads they're running are talking about electricity rates. They're all talking about some of his past investments, sort of trying to paint him as not as progressive as he is, which I think is just important for voters to kind of wade through.
Yeah.
On the other hand, we have Xavier Becerra.
Yes. Yeah, and I think with Becerra, again, it's like he really wants to point people back to his time in government because no one else in the race has that at this point. And to me, it's fascinating because, and you detailed this really well in your story, you can argue about whose experience did what. There is no more relevant experience to running for governor than being attorney general. It's thousands of employees. It's overseeing so many different issues.
Right. The policy areas, it's just, you can't sort of name another job in state government where you have to be a master of all.
Right.
The way the governor does.
So we've seen this governor's race kind of from the beginning be a one-upmanship of who can fight Trump the best. How would you assess that part of Becerra's record as AG? Like, he took office, Trump is in the White House.
Yeah. I think that's a fair thing for him to run on, right? He did sue the Trump administration like 120 times. He was very aggressive with a lot of those lawsuits and in helping other states. Like, I do think he came in really with this sort of eyes on healthcare as an issue. And that's something I talked to folks who were in his administration about. He had just come from 30 years in Congress helping Nancy Pelosi shepherd the Affordable Care Act across the finish line. They knew that that would be a big sort of target of Trump and Republicans. So on healthcare, I think you can absolutely say that that was something that he not only fought to defend here, but helped other states defend, right? I think these are things that people like to hear and they want to hear about a fighter right now, but that is not the governor's only job. Yeah. And I think that that's where, like with Becerra, you kind of get into this territory of like, okay, then how did he play on other issues beyond healthcare? What was his record with oil companies at a moment where prices are spiking? What was his record on being the top cop? Was he okay with policing the police? How is he on housing? And I think on all of those, there's certainly areas of his record that were more progressive or sort of, fit with the Democratic Party's sort of vibe in this moment. But there are also areas where he was incredibly cautious. And to me, the kind of overall, takeaway from his time as AG is that he was not as comfortable taking on powerful interest group closer to home. He was much more sort of willing to play within the margins of what was already kind of on the table than to be aggressive. And I do think that sets him and Steyer apart in this race.
Yeah. Well, dive in just on the oil. I think because that's an area where we've seen the last two governors, Brown and Newsom, kind of take a row left, row right approach. It's a struggle as we're in the middle of this energy transition to figure out just how much pressure to put on moving the state away from all of its fuel consumption. How did Becerra approach that issue as AG?
Yeah, I mean, he definitely had some very pro-environmental policies and cases that he pursued. I think environmental justice, thinking about pollution in communities was big for him. What folks on the kind of, climate action side will say is they didn't feel like he was as aggressive as he could have been pushing back against oil companies. We've seen a bunch of lawsuits filed in recent years, essentially alleging that these companies knew that their product was harmful, kind of like the tobacco lawsuits, and they didn't do anything to protect the public, to protect their own shareholders. Those lawsuits have developed in recent years, but that was an area where some of the more progressive activists said we would have liked to see you do more. And then I think in this race, we've seen clearly the big oil companies, the fossil fuel companies, are far more comfortable with him. They put money both behind his campaign directly and behind these independent expenditure accounts. He's defended that. He said, look, we still need Chevron. Everyone's not driving an electric car. That is true. But I do think in this moment, it is raising good questions, just kind of about like what would be his approach when we are in a state where California often leads the way on a lot of these policies. Would he be willing to kind of buck the status quo? I think his critics would say no, and his defenders very clearly say you have to look at the whole of his record. He did do a lot. He maybe just didn't take on every single tiny little fight. So I would encourage folks, check out Guy's story on Steyer and all the spending against him. Check out my story on Becerra and his record as AG. Check out our voter guide. Those are all on KQED.org. And also, we interviewed Hannah Dry, our New York Times reporter, who really dug deep at the time into some of what happened with migrant kids when he was HHS secretary. That's in the Political Breakdown feed. Check it out, because that's really fascinating, too. That's like
Great
a whole
episode.
other area. All right, we got to say goodbye to Guy. Thanks for being here. Welcome back to Political Breakdown. I'm Marisa Lagos. Today I'm thrilled to welcome Marsanne, Weese, and Rose Mishaan. They're defense attorneys who just won a big case at the California Supreme Court that could change how we treat people accused of crimes in California. Welcome to the Breakdown.
Thank you.
Thank you.
So thrilled to have you both here. So talk about just briefly the case you litigated. This involved a credit card that belonged to somebody else and a $7 hamburger.
That's correct. The trial attorney, Esther Aguayo, contacted us because she had attempted to obtain bail for Mr. Kowalczyk 3 times. Mr. Kowalczyk was unhoused at the time. He had found some credit cards. They were not stolen, and tried to buy a hamburger at Five Guys. The cards didn't work. He walked out. He was then charged with a couple of nonviolent felonies.
He didn't even get the hamburger.
He didn't even get the hamburger.
All right.
And then he was detained in custody on a $75,000 bail.
For how long was he in jail?
He was in jail for several months.
Okay. And so what was the basis of the case that you took on?
So our basis was we had done several writs in San Mateo County. When I say several, at this time it was probably more than 30 writs on bail and detention. And so we found that it's just not fair that a person who cannot afford money cannot afford bail is going to stay in custody. Whereas if someone else could afford it, they would be out of custody for the same crime. So what we did is we filed a writ, and we filed a writ to the Court of Appeal. It got denied. We went to the California Supreme Court. They sent it back down to the Court of Appeal. We then litigated it. So 11 motions later, we got this opinion.
And so what did the Supreme Court find?
The Supreme Court found 2 very key issues. One is that the California Constitution limits people who can be detained. And the California Constitution specifically says you have a right to release unless you are charged with violent or sexual felonies or threatening felonies. So that was one. And the second one is that you cannot detain someone on unattainable bail.
So basically, if you set it so high that someone can't pay it, that's not really offering them bail.
Correct.
All right. Well, Rose, I want to kind of back up here, and we'll come back to this case in a little bit. But can you just explain to us, like, what is the history of bail? Has this always existed in the United States? Has it changed over the course of our nation's history?
Sure. And, we actually had a few professors file amici briefs in this case speaking to that issue. Money bail, as we understand it, is relatively recent. I mean, historically, bail was going back far enough, it was somebody of high standing who can basically vouch for you. It was an assurance to the court that this person would be released, would come back to court. It traditionally was not tied to public safety. It was only tied to that person returning to court. And eventually that morphed into this system where basically arbitrary money amounts were assigned to specific types of crimes. And that's how we got our modern bail system. But that was never what it was intended to be.
And so is it different from state to state at this point, the way bail is sort of implemented and used by courts?
To a degree, there certainly is, I believe, a nationwide movement away from money bail because there's a recognition that it's not rooted in what bail has historically been used for. And it also presents the possibility of very unfair treatment for people based on how much money they have. And so there is that move nationwide. And we, in fact, relied on a lot of other states in preparing our briefs in this case to see how other states were handling it.
I mean, you're both defense attorneys. You're on one side of the aisle on this, so to speak. But in your mind, what's the purpose of bail?
The idea is that it gives the defendant a reason to stay engaged with their case. So it has to be something that they can attain so that they can sort of obtain a stake in the proceeding. And again, the types of cases that Kowalczyk addressed are less serious. They're the nonviolent felonies, misdemeanors, cases where someone isn't generally facing very long sentences of incarceration. So it gives them some incentive to stay engaged with their case, come back to court, follow the directives of the court.
Yeah. I mean, and I think that is at the heart of sort of what the tension is between prosecutors who are unhappy with this ruling and obviously you guys who wanted to win it, which is this idea of like, how do you engage people who maybe they're not facing a murder charge, they're not posing a threat to public safety, but they might just sort of throw away their summons and not show up. But there's this other side to it, which is that there's very different outcomes for defendants, whether if they stay in jail versus whether they go home. Can you talk about that? Like, I think there's some like clear things like, oh, if you can't get out of jail, you can't, parent your children, you can't show up at your job. So like that's one thing I've heard talked about over the years. But there's also really clear different outcomes in criminal cases, correct?
Yes, and Justice Groban, who authored the concurring opinion in this, made specific note of that there's a tendency in courts, so if somebody's in custody, a lot of times they'll be offered what's called a credit for time served deal, where the DA will say, well, if you plead guilty to this charge, you can get out today. Whether or not you're guilty, that's a very, very strong incentive to plead guilty. Then the prosecution gets their conviction, the person gets out, but justice isn't really done. And so people who may be inclined to fight their case because they are innocent or they believe they have a defense will forego that so that they can get out sooner. And so that's definitely a concern with keeping people in custody.
So, Marsanne, talk about if cash bail is not the option, what alternatives exist?
There's actually a lot of alternatives, and in fact, there was some amici that gave a whole list of alternatives because what's the purpose of a person of bail is to ensure that a person comes back to court. So when you're looking at ensuring a person comes back to court, you look at the totality of the case, is what Kowalczyk said, the totality of circumstances. So you can have them on GPS monitoring on serious cases. You can have them check in with the court. You can have a whole variety, including they can go to, the court can order that they attend classes, whether it be mental or drug addiction classes. And the whole purpose is to take away any barriers that would prevent a person from appearing in court.
So do you believe, I know prosecutors, as I said, are not happy with this ruling. Do you believe that bail is actually being used to ensure people come back to court, or is it more being used to essentially, put people behind bars who haven't been convicted of crimes because maybe they are repeat offenders? Maybe there is this incentive to get them off the streets.
And I think that bail is now used to keep people in custody. Mm-hmm. And in fact, in several cases that Rose and I have had, that has been specifically stated by judges and by prosecutors. The judge will sometimes issue bail at an amount the client can afford. And then once the DA says, well, we want it higher, for no other reason but to keep a person in custody. And the concurring opinion by Justice Groban has the last two lines is great in that opinion because it says that this practice ends in California and that you to look at what our California Constitution says, which is in pretrial cases, you have a right to release, and something that the courts have said since 2018, which is liberty is the norm. So freedom is what the court should be considering first. And the court should see how a person can be free on the streets while they have a pending case in nonviolent or misdemeanor type cases.
I want to push back, though, a little because you do have these prosecutors who are being held responsible for the conditions on our streets, especially in the Bay Area, right? And in this case, the defendant had more than 60 convictions and a history of failing to adhere to release conditions. And an algorithm that was used, which is part of what I think a lot of people who support bail reform is like, okay, let's use these algorithms to essentially say, like, what is the risk that this person won't show up or that they might be dangerous again? It gave him the highest possible risk score. Again, he's not a violent defendant, but he is one that has a history of not sort of complying with these court orders. So how do you kind of square that circle?
Sure. So when you're looking at these algorithms that different counties use different algorithms, and the problem is with these algorithms is there's no science behind it. And when you're looking at San Mateo's algorithms, what they take into account is if you have a job, then that if you don't, that's goes negatively disfavored for you. They also look if you have any drug convictions, that goes against you. So when you're looking at these algorithms, that is not something that will help the court, I believe, in order to determine how a person will comply with the court orders. And so when you're looking at the Kowalczyk case, looking at the non-financial conditions of release of the case and the person. So, for example, with Mr. Kowalczyk, if there's a history of him not coming in, the question is, and there's also a history of him attending many court appearances. So it's not like he would not make court appearances. He, over the years, and he does have a lengthy history of nonviolent misdemeanor cases, but he attended court regularly, and when you're looking at why he didn't attend, that's where I think the defense attorney, which in this case, Miss Aguayo, she presented a treatment plan. And he was also on the wait list to get housing, and he had gotten the housing. And so there's what the pushback is that we have to be more prepared for these non-financial conditions of release for clients. And that's something that has never been done. So looking at the history, I don't think is fair to say that people aren't going to come to court, but people have not been given the opportunity of certain non-financial conditions of release.
Rose, I want to pivot a little back to the legal questions here because this conversation around bail has really changed over the last decade. There was a push, among activists and others to really sort of sideline cash bail. And some of that's been through attempts. There was a ballot measure that failed to eliminate cash bail in California. There's been legislation, but there's also been these court cases. And the Kowalczyk case really is predated by the Kenneth Humphrey case. Can you remind us what that case was about and who's Kenneth Humphrey?
Yes. So Humphrey was a case that came out of San Francisco. I believe it's a San Francisco Public Defender's Office that pursued that writ. And in that case, the defendant was detained on, I believe it was $600-something thousand bail and eventually reduced to $350,000 bail. And in that case, it actually was a violent case. It was a robbery, but it was the circumstances that the court found didn't warrant detention, but warranted that high of a bail that was unaffordable for the defendant. And after litigation to the Court of Appeal and the Supreme Court, the court held that detaining someone solely because of a lack of ability to pay is unconstitutional. So that case sort of set the stage for Kowalczyk that then built off it.
So stepping back here and thinking about, say, a nonviolent case like Kowalczyk, with these two court decisions in the books now in California, how should someone like him be handled by a court?
So, it's important to remember that courts still have quite a bit of power to detain people who are actually dangerous. Section 12 is pretty robust, and it does offer detention without bail as an option. And that's something the public should really like, because it means no matter how wealthy you are, you would not be able to buy your way out of custody if you're charged with a qualifying crime. And so it does give the courts the tools to sort of treat each defendant as needed. So if they're subject to detention under Section 12, the prosecution needs to present a certain threshold of evidence. If that threshold is met, that person can be detained without bail. If it is not met,
if they're dangerous.
if they're dangerous, if they prove both that the crime occurred, that person did commit a crime, not beyond a reasonable doubt, it's a lower threshold, but there's some evidence they committed the crime, and there's also evidence that they cannot be safely released. That person can be detained. For people that don't qualify with those types of offenses, the court can tailor treatment plans to their specific needs, which is actually a lot more beneficial than just sort of releasing someone on a monetary bail without any support.
I mean, given, though, the way that Humphrey kind of set the groundwork for the case that you all then litigated, and the fact that we haven't seen a sea change in California, how do you think this is going to be implemented? Like, are you as defense attorneys going to have to go and sort of challenge every individual bail case? Or do you think judges and prosecutors are going to follow what you see as the real letter and law of this ruling?
I think we're seeing kind of a little bit of everything, because everyone is trying in the criminal justice partners in every county trying to figure it out. And in some instances, prosecutors are coming with lists and say, okay, these fall under Qualsic, so we can talk about releasing these. Then you have private attorneys such as ourselves or court appointed that are then bringing bail motions. And then you also have public defenders or the private defender panel in San Mateo getting a list of cases of people that are in custody because of high bail. So what's happening now is the first phase is getting these people on calendar in order to have the bail. Then the next part is, how are we going to ensure that the courts follow Qualsic? Mm-hmm. And I think judges generally truly want to follow the case law. And so I think that there will be times when I think every county, because it's so new, that we will have to file appeals. And I think that the defense bar is prepared to do that. And I think in some instances, the prosecutor is prepared to do that. And so I think that it's kind of a wait and see right now, but it seems like in most counties, everyone is attempting to work together.
Are you concerned that there could be kind of blowback to this? We did see a lot of steps back during the pandemic when there was so much concern about crime. DAs say that this is a tool they're using to keep our streets safe and clean and make sure that people answer. Like, do you have any concerns about that?
I do, and I think it's already started because there's a sense of fear-mongering that's, I think, has started where now our streets aren't going to be safe. But that's kind of like clickbait, because the court specifically said violent crimes may be detained, and violent and sexual or threatening crimes, the courts can still detain it. And also, these are cases which do not look at a lot of jail time generally. So in other words, it's not as if these individuals that fall under Qualsic wouldn't be released. Mm-hmm. They would eventually be released, generally within weeks or months. So I don't believe that it is that we're going to see violence in the streets because of this.
I mean, but Rose, just to finish this up, there is a sense that, there was a moment where San Francisco and the Bay Area got out of control. And some of that's not about violent crime. Some of that is just about street behavior and things like this. So I guess I do wonder, are we talking about just the need for a much broader, deeper sort of social safety net to help folks like this? Because it seems like right now we're using the jails for it.
Right. I think part of the problem is you can't use incarceration, especially pretrial incarceration, which is very limited, especially as Marsanne said, for these types of defendants. Well, it doesn't really make a difference if they get out today or in 3 weeks after they've, pled guilty to something. And then they get released without any support, as opposed to getting released weeks earlier with support. But we can't use that sort of blunt tool of incarceration as a way to solve all of our social problems. And I think one good thing that is in the Qualsic decision, especially in the concurring opinion, is an encouragement to counties to shift the resources. So if you're going to have less or fewer people in jails, we can shift those resources to really building up those conditions of release, which are a stepping stone. And hopefully those would help people transition into more stable situations.
That is Marsanne Weese and Rose Mishaan. They're defense attorneys who just had a big one at the California Supreme Court. Thank you both for coming in today.
Thanks so much for having us.
Thank you.
That is a wrap. Political Breakdown's a production of KQED. Our engineer today is Christopher Beal. Our producer is Izzy Bloom. Our video team includes Alex Tran, Jim McKee, Matt Morales, Jalar Zeta, and Vivian Morales. I'm Marisa Lagos. See you next time.